Good morning, everyone, and welcome to the Case Metrics webinar. We still have people that are signing up, so we're going to give them a few minutes to do that. And while more people are joining us, I'll take a moment to welcome you to our webinar. And today's host is Michael Haggard of the Haggard Law Firm in Coral Gables, Florida. He really needs no introduction. Most of you know all about Michael and his firm. They're best known throughout the country for their impressive verdicts in the premises liability arena. In fact, Michael was, I think, one of the first attorneys, if not the first attorney, to secure 3 separate verdicts of $100 million or more. 2 of those were on behalf of children in really tragic pool accidents, and the other was in a negligent security case. I think that one was a shooting with a catastrophic injury. The thing that I like most about him is how he's always giving back and paying it forward, perhaps more than anybody I personally know. He serves on the advisory council for the National Drowning Prevention Alliance. So he doesn't just work on these cases, he learns a lot and tries to find ways to make things better and to try to prevent these things going forward. Michael is always on the board of directors for the National Crime Victims Bar Association, and he's a member of MAD, Barristers Council. He's also a supporter of the National Center for Victims of Crime, and he's on the national board of the Polycystic Kidney Foundation, a cause near and dear to his heart. Today, Mike is going to talk to us on latest trends in negligent security cases. And before we get started, I just wanted to touch base with you on a couple of things. You will find chat and Q&A buttons at the bottom of your screen today. So if you have questions during the presentation, we ask that you log your questions in the Q&A portion. Should you have any questions of a technology nature, we ask that you log those in the chat. We have our Zoom expert, Mary Ellen, on board to help with anything of that nature. So I think with those preliminaries out of the way, I will give you Michael Haggard. Thank you very much.
Well, thank you, Kim, and it's great to be with everyone today and get to talk to you about these types of cases with negligent security cases really across the country. I know there's folks from many different states on the seminar today. And one thing I'd like to do is really encourage you to look at these cases and to take these cases. I would argue that there's never been a greater time in the history of our court system to advocate on behalf of crime victims. Just look at the trends lately. If you look at the United States Air Force in a church shooting that didn't even happen on their property, where they paid $230 million to settle that case. The Parkland case that I'm privileged to represent several families in that terrible tragedy that happened down in Broward County, Florida. Those cases with one remaining defendant have already settled for $152 million. You look at the absolute heroic efforts of the lawyers on behalf of the Sandy Hook families suing Remington and the gun manufacturers, piercing that veil and getting a settlement of $73 million. And then we looked at Las Vegas, which I think when people originally saw that case might not have seen an inadequate security case. And that case settling for over $500 million. And the reason I mention those type of cases is, granted, they're the big ticket, gigantic settlements and everything like that. But they're in cases that several years ago, if you talk to a regular criminologist, you talk to an expert that some of us run our cases by, they probably would have told you, you're not going to win those. Certainly the gun manufacturer case, probably some of the mass shootings, because they would have told you that those are so rare and they can't be prevented. And some of these are targeted. And so I want to talk to you today about trends in negligent security cases, in cases that normally we would have turned down over the last 10 years. And I want to show you today some examples of where these trends are going, and that these are cases in your law practices you should be thinking of taking. I'm going to start out first in talking about domestic violence cases. I was at a mediation Saturday morning in a case where my firm represents a quadriplegic who was shot and rendered quadriplegic by her ex-husband, somebody who had stalked her through social media, stalked her at her job site, prior instances. That's why she ran away from him. And he came into an apartment complex and he shot and killed somebody that she was dating and rendered her a quadriplegic. That case 10, 15 years ago, nobody would take. Why? Because every expert would tell you it's a targeted crime. It's a non-deterrable offender. That offender went after our client. It's not a crime of opportunity. And I would tell you, we need to lose those notions. We need to focus on what's important in a negligent security case. And that is the premises itself, to focus on what is wrong with the premises. What is the problem? What is the crime history at the premises? What did they do wrong? What security measures didn't they have that could have been a legal cause of the incident? Too many times we go right to, well, it's domestic, and we don't want to take it. And I would really encourage you, and I'm going to use examples so that you absolutely don't fall into that trap. I know I've got something on the screen here, but maybe is, there we go. So why have we shied away over the years on domestic cases? Because they're ultimately a targeted crime. I am so tired of hearing the defense in my cases, the insurance adjusters say, well, it's a targeted crime. Well, so was Parkland. Absolutely was a targeted crime. There's no question about it. Nicholas Cruz came in that school to kill kids. That's what he intended to do. A number of these cases are targeted crime. Nowadays, that is not rare. So security needs to be set up, and business owners have a duty to prevent against what? Targeted crime, not just crimes of opportunity. Criminals have changed. I was talking with Kim and Marilyn before we got on this morning that criminologists are studying things of 10, 20 years ago. Today's crime fabric is totally different, and we need to understand that. And the great thing for you, if you're a crime victim lawyer, if you handle these cases, that is what you are. If you're a crime victim lawyer, is that juries understand this. Juries absolutely understand what has changed with crime over the last 10 to 20 years in America and what has changed with regard to security. I can't mention enough that domestic violence is part of the crime prevention fabric in America today. I started out my career, I'm hesitant to say how long ago it was, but about 27 years ago in the Miami-Dade County Public Defender's Office in a special division that was set up to defend what type of cases? Domestic violence. 27 years ago, our criminal justice system started to put into place divisions that were solely handling domestic violence crimes. So how can a business in 2022 say, oh my gosh, it's domestic? We never knew in a restaurant we would deal with a domestic fight. We never knew in an apartment complex we would deal with a domestic crime. That is absolutely not true. That is so far from the truth that we need to turn it on its head. Most of crimes and violent crimes are just that. They're domestic. And therefore, they needed to be guarded against. And that's one of the primary reasons I want to talk to you about handling these type cases. And the statistics bear it out. One thing, if you're handling these cases, please use all of the advantages you have through the government associations that are out there, both federally, statewide, and locally. The Department of Justice funds over $200 million of grants towards studying domestic violence. Use that. I mean, look at these statistics that we have right here. 1.3 million women and 835,000 men are physically assaulted by their partners every year. Obviously, we know that women are significantly more likely than men to be a victim. I want you to look at the last statistic. because when we talk about handling wrongful death cases and homicides, so when I look at negligent security cases, which is a significant part of my practice, out of all the women murdered in the United States, 40 to 50% were murdered by their intimate partners. Literally, half of the homicides are domestic violence. Imagine you're taking the deposition of a vice president of a property management association that has apartment complexes throughout the Southeast, America, the West, wherever you are. How can someone say it's not foreseeable that someone could be killed by an intimate partner when 50% of the homicides in the United States every year of women are exactly that? That is the definition of foreseeability. And we need to use these statistics in our cases. You're experts when you use a former chief of police, a criminologist at your state university. They'll focus on the crime grids and the crime statistics of your particular location, whether it's a restaurant, whether it's a shopping mall or an apartment complex. You've got to get them to use the national statistics, because once they use these and they're peer-reviewed studies, you're not only going to survive a Daubert challenge, but you are going to have foreseeability on a platter for yourself in these cases. The UN keeps these. There are so many organizations, and I would encourage you now that you do this research. We may have experts on this panel, and I don't want to offend them, but I've been doing this a long time, and I can tell you that the lawyer needs to do the research. No one knows your case better. And when you're a crime victim lawyer, you need to know of these particular studies that are out there. Now, a lot of domestic violence cases, and I'm going to show you some different examples of cases that we've had over time, do deal with housing. I would tell everybody on this webinar that some of the best negligent security cases are in apartments, are in condos. The reason why that is we've done 500 focus groups in these cases and mock trials. And there is a heightened sense of duty to a resident of an apartment complex or a condo over someone that might be visiting a strip mall, might be having lunch at a restaurant, or even going to a bar. Now, reason is it's your home. It's your home. And the owner of that apartment complex has a duty to keep you safe in your home, where kids live, where families are raised. There's a heightened duty there. And we know that this is where domestic violence occurs most of the time. So we need to look at our landlord-tenant laws. We need to look at any studies that have done not only through HUD, by the way, another great federal agencies. And I say this lightly, but maybe not. These federal agencies spend money like a drunken sailor on grants, on studies, stuff that unless you're getting it, your expert's never going to bring to your attention. And for instance, in this particular study that we're talking about, maintaining safe and stable housing for domestic violence, this was commissioned by HUD. And what do they have inside these studies? Courts have found that landlords must take reasonable precautions to protect tenants from foreseeable criminal assaults. This duty arises where the landlord has noticed a prior criminal activity that puts tenants in danger of physical harm. Well, that really is the law everywhere, but it's codified here. And you can imagine it goes and dovetails into domestic violence and sexual violence. That some states have statutes requiring landlords to change the locks to its tenant's dwelling after the tenant has suffered domestic or sexual violence. 13 jurisdictions have adopted such laws. Ladies and gentlemen, this is not the most recent study. So when you have a case that I was talking about before, the one we mediated on Saturday, our expert is going to come into trial in that case in July and talk about that particular apartment complex, as every apartment complex in the United States, has a duty and has to understand that domestic violence can occur. And that's why you need security guards. And that's why you need access gates. And that's why you need surveillance cameras. In apartment complex cases where an estranged husband or estranged boyfriend comes into an apartment complex and lays in wait, one thing that we all know, if you remember back to when you lived in an apartment complex, maybe in college, or where you live today, maybe in a high rise, parking is at a premium. The number one complaint at these places is people are parking where they shouldn't. So what do they need? Decals to get in there. That's what the security guard looks for. That person's parked illegally. Well, an estranged husband doesn't have a decal. And I could show you many cases where we've won the case where if they just did a tour, that a security guard, a guardian of the property did a tour, they would have saw somebody parked illegally, hanging out in their car, and got them to leave the premises. And that would be something that obviously would help us in our case. Again, going through the same study here, landlord may have a duty to provide additional security measures for the victim tenant. Several jurisdictions require tenants to prove the landlord knew of the offending tenant's tendency towards violence and failed to take reasonable precautions to protect the innocent tenant. Ladies and gentlemen, that's talking about when people live together. Okay, we're not talking about an estranged husband here that came off property. We're talking about here where jurisdictions have found that if there's an abusive relationship and there's a victim that's continually victimized by the other tenant, the actual apartment complex or a homeowner association may be found responsible or may need to provide additional security measures. That is a high standard, and we need to be aware of that. So I'm going to give you an example of a case that I think sometimes can do best. And I know that there may be questions. I'm not going to answer them now during the chat because I'll get distracted, but please at the end, we'll go over those. So put them in the chat now, and I'm sure Kim and Marilyn will read them out to me at the end and we'll go over those. So please keep loading up that question and answer, and we'll answer at the end. So this was one of the first domestic violence cases we took. This is, as you can tell, occurred almost 18 years ago. And this case went to trial and settled during the middle of trial. And I'll talk to you a little bit about that. Denora Garcia was in an abusive relationship. Her husband, the father of her two children, beat her continually to the point where she got an injunction against him, and she found an apartment complex that had a gate, that had and promised security guards, and she went there to live anonymously. In fact, one of her best friend's husband was a police detective, and he gave her permission to go lease it under his wife's name. How did the estranged husband find where she lived? The process server serving the injunction put her new address on the service of process, served him, and basically gave him the address. I got into the case too late where I couldn't sue that process service agency, unfortunately. I want you to look at this news article where at the end, family members said Garcia moved to the complex because it was gated and she felt she would be safer. That's exactly why she moved to this apartment complex, because she felt she would be safer. They promised a gate, access control. If you ever handle one of these cases, the first thing that you need to do is go directly to the apartment complex, not only document the security measures they have or the lack of security measures they have, but also go and get the brochures. Go have your investigator be a prospective tenant and go and get the brochures at the apartment complex to see what types of security that they promised. Obviously, go on the website before it's scrubbed and get everything you can. Go on all their social media, because this is what they promised Denora, a working gate. At the same time, in this case, they promised security, and they promised a security system where the security guard would go to certain checkpoints throughout the apartment complex, what we call a tour, that they would go on a security guard tour that makes sure that the security guard is doing what they're doing every night. She went there, she relied on these representations of security. That's why she moved there. Well, On the night of the incident, where her ex-husband came into the apartment complex, the gate was not working. The gate had not been installed. He sat and waited for several hours with no parking sticker. And when Denora came out of her apartment, got into her car, he shot 17 times into that car, killing Denora and taking two children's mother from them in a absolutely targeted domestic violence event. Absolutely targeted. Their defense, there's no way you can stop this. He was going to do it no matter what. In fact, when he left the scene, he went home. The SWAT team surrounded his apartment complex and he took his own life. To which the defense expert said, see, he wouldn't have been deterrable. If you had an off-duty police officer there, he would have shot the police officer. He wasn't worried about himself going to jail. There's nothing that could have deterred him. But we focused the evidence in our theme in the case on the fact that they promised a gate and it didn't work. They promised a security guard who that night, because it was raining, didn't do her tour. She would have seen his car there and she would have either gone up to it, said, what are you doing there? Or reported it and called the police. Now, the defense can come in and Monday morning quarterback and say all day long that, well, he would have shot the security guard. Well, we don't know that. And it doesn't give you an excuse not to do anything. You've got to keep the focus on the premises and what they did wrong. I cannot stress that enough. Don't fall into the trap of the defense saying later on, sure, we committed all these violations. Sure, our gate didn't work. Our security guard didn't do anything that night and kept in her own office and probably watched TV and was on the phone texting people and everything along those lines, didn't do her job, but it wouldn't have mattered anyways. Yes, it would have mattered because that was the night, no other property. That was the night that Denora Garcia lost her life. And it very much was because of the failure of these security measures. So that was an apartment complex case that we had that as we went through with the second manager on the stand, all the security violations and how they should not have happened, how it was a violation of standard care, how they knew better, how they delayed, all the things that you want in evidence of negligent security case. Obviously, the insurance adjusters pulled us aside and resolved that case, which they said they would never pay in that particular domestic violence case. That was 18 years ago. Ladies and gentlemen, so much has changed since that time. These cases are getting better and better for all of you and all of us to handle. So this is a case I want to talk to you about at a restaurant, because again, I would tell you that domestic violence happens everywhere. Obviously, I've gone over with you the HUD recommendations with regarding safe apartment housing for domestic violence victims. Restaurants are the same. We've all been to a restaurant where a husband, wife, or a girlfriend, boyfriend, when a estranged boyfriend comes in and there's a fight. You know, half of bar fights, probably 75%, I don't know that there's a study on this, are because of one thing, a fight over a woman, a fight over a man. That's how 75% of bar fights happen. The industry knows that. This is a tremendously awful case where Michael Bubnow was a car salesman in Ocala, Florida. One of his colleagues had just recently been divorced, and they simply went to happy hour at Chili's in Ocala, Florida. And I can tell you, Denora Garcia's case, there wasn't some incredible crime grid, high crime problem at that apartment complex. There obviously was some activity. There was minimal activity at this Chili's. But on the day of this incident, her estranged husband came through the front doors at Chili's, absolutely shouted profanities at Michael Bubnow, at his ex-wife, calling her all sorts of horrible names, accusing her of sleeping with Michael Bubnow for about a 3-minute tirade. He went outside, never left the premises, as you can imagine. When Michael Bubnow and the ex-wife exit the Chili's, get in their car. He comes down off a hill and unloads about 10 bullets, killing his ex-wife and rendering Michael Bubnow paraplegic. Classic domestic violence, targeted crime in Ocala, where there was not a lot of crime. And again, Chili's told us they would not pay in the case. Well, when you have a case against a bar, a restaurant, anything of that nature, you've got to find the industry standards, because they obviously are for fights, for arguments, but they dovetail into domestic violence. And these are Brinker's policies. Brinker's policies, procedures, and standard of care, they mirror the industry standards. If you're handling these cases, you need to be a member of, and you need to get the materials of the American Society of Industrial Security. That is ACES. At the end, I'm going to give you all my contact information. Feel free to call me, contact us anytime to get you these standards, because you can't handle these cases without knowing these standards. Brinker's, if any of y'all remember, owned Chili's, Ruby Tuesdays, Fridays, all those different restaurants at one time. And these are the standard procedures. If someone enters a facility, threatens someone with a verbal altercation, waiters, waitresses, busboys are trained to try to calm the situation down and then call the police. And that's the basics. You know, we can go through each one of these because they lay them out in a redundancy in all these procedures. And again, I don't care if you have a case against Chick-fil-A, McDonald's, these are always the policies. They are the industry policies. They're for every domestic, well, let me say that again. For every commercial establishment you can think of that you can bring a case against for negligent security, I promise you there's a trade association that has standards. Gasoline stations have their own lobbying industry. Apartment Association, the American Apartment Association, restaurants and bars, hotel industry, everyone. And these are the procedures when you have a disruption and what I call active negligence versus what we typically think of in a negligent security case is when you have a prior criminal problem that they should have had security. Here, where you have an active negligence problem, these are the standards. And I've explained to you the facts in the Bubnow case, that tirade that occurred. And very simply, we all love to try cases where you have rules and you have violations of the rules. Everyone here is a failure, every single one, which is an incredible thing to show a jury. We all talk about the rules of the road. We talk in jury selection about certain jurors that are rule followers, that in their job, that's their absolute role and responsibility is that others follow the rules. These are great illustration, great demonstratives to use. And in these cases, there's no answer for it whatsoever. So when you have that type of domestic violence incident, and again, those standards can apply to any type of fight in a bar, in a restaurant, but it certainly can help in that case. In that Chili's case, that case resolved for several $1 million after, again, they told us they would never pay in a domestic violence incident, that Chili's would never do it. And that case resulted in that. So please, we've talked about domestic violence cases. Do not shy away from these cases. They're incredibly, incredibly important. One thing I talk about when I talk about those cases is, I was in law school. Actually, I just became a public defender when the O.J. Simpson verdict was read. I'll never forget it. I was in a courtroom. The state attorneys were on one side, the PDs were on the other side. And you think about that's when domestic violence came to the forefront of a problem in the United States. It was 27 years ago, the verdict itself. 27 years ago. So there's a plethora of information out there. And I would also say, to get on my soapbox a little bit, there's no one that needs us more than domestic violence victims. So So please consider those cases. Mass shooting liability. Well, this used to be a rare occurrence. I'm going to show you a case in here, and I don't know, I can't see everybody on the grid here, and I don't know what everybody's ages are. But I remember when I was about 11, 12 years old, and there was a terrible shooting in Southern California at a McDonald's, and several people were killed and several people were injured. It shocked the conscience of the United States because it just hadn't happened that much. And a lawyer had the courageousness to file a lawsuit against McDonald's on behalf of those victims, and he was thrown out. It was thrown out with a court order that said mass shootings are as rare as a meteor hitting the planet, and that they can't be prevented, and they can't even be foreseeable to a business owner. Well, wow, have times changed. I wish they hadn't. I wish I couldn't guarantee to everybody on this audience today that by the time you watch your nightly news, wherever you are, there's going to be a mass shooting today in the United States of America. There's going to be 2, 3, 4, 5 people at a minimum that are killed or shot in one incident at a location today. And that is a pathetic truth to our society, but it's where we are. And businesses don't get the opportunity to say anymore that how could we predict a mass shooting? Because it has happened everywhere. This is a presentation that I made to the American Society of Industrial Security just last year, telling businesses, over 20,000 attend that actual seminar. It's the biggest in the world. And telling them that you're out of your mind if you're putting your head in the sand and not considering active shooter training and mass shootings that could occur at your business. Well, Harvard conducted a study back in 2011, folks, 11 years ago, that the number of mass shootings were rising despite the number of incidents of other types of homicide by guns remaining stable. Now, unfortunately, in 2022, both are on the rise. Mass shootings and individual homicide and gun incidents. So we've made no progress. This study showed that prior to 2011, the United States experienced on average a mass shooting every 200 days. Well, following 2011, the rate of incidents for mass shootings had increased to every 64 days. That was 11 years ago. Outpaced every country in the world by tenfold. And now look where we have come. This is after the first 9 months of 2019. There were at least 21 deadly mass shootings, and it was happening every 2 weeks. And it had claimed over 124 lives in just 9 months in 2019. You look in 2019, and one that I always remember is the back-to-back shootings on the same day in El Paso, Texas, at that Walmart, and Dayton, Ohio, in their entertainment district. The reason I remember that is I was at the Brady Center to End Gun Violence's gala event that day in Washington, D.C., as you have 2 mass shootings occur in our country. And that's where we are, unfortunately, in this country. Now, when you talk about foreseeability in these cases, 47% of mass shootings since 1982 have occurred in the last 8 years. When you talk about jury appeal, 6 Americans live in fear that a mass shooting can happen in their own neighborhood. And let me tell you what is striking about that. Most people feel they live in a good neighborhood. They chose it. Not everybody obviously gets to choose exactly where they live. But most Americans do. And they get to choose places that they live, and they still think that they are going to be a victim of a mass shooting. Because unlike singular gun violence, which a majority occurs in low housing, in areas of cities that are low income and have socioeconomic issues, mass shootings occur everywhere. It's an equal opportunity offender. And Americans understand that. And that's something that's profound in these cases. So I want to show you and encouraging you to handle these cases. I'm not just talking about the giant cases. I'm not talking about just Parkland, Vegas. I'm talking about, and I hate to say this, but it's true, mass shootings that, yes, will make the national news, but they're not the ones we hear about every day. These are cases from a criminology standpoint and from a court standpoint used to be unforeseeable. Now they are totally foreseeable. And for our purposes, they are totally winnable. And the only way we're going to stop mass shootings, ladies and gentlemen, if you're not going to get gun reform, which I think everybody on this call knows, we're not going to get gun reform with this Congress to agree on that, that you better have better security at these places to prevent these from occurring. And that's our job as crime victim lawyers. Well, this was the case back in 1984. And that started it all. It was a terrible opinion. So unlikely to occur in the setting of modern life. So I'm going to take you through the timeline of how these cases have changed in the court's opinion. We all remember the Virginia Tech massacre, where an undergraduate student shot and killed 32 people, wounded 32 others, making it the deadliest school shooting in American history and the deadliest shooting up until 2016. The original lawsuit resulted in the university being found liable, and that was on the deaths of Julia Pride and Aaron Peterson. But in 2014, the Virginia Supreme Court overturned the decision, stating that the Commonwealth did not have a duty to warn students about the potential for criminal acts of a third party. That case hinged on the assailant's record at the school, his prior problems. It was very assailant-centric, meaning he was the problem. It wasn't that they didn't have enough security guards, didn't have enough off-campus police. There were other allegations throughout that case. So that's a case that was won at trial and then later on was overturned by the Virginia Supreme Court. Then we go to Aurora in 2012, and we probably everybody is familiar with Aurora during the screening of the Dark Knight, and the 12 people dead, 70 injured in that. And in that case, taking from the Lopez McDonald's Corp case we talked about earlier, the defense motion dismissed said they likened a mass shooting to a circumstance such as a meteor falling from the sky. This was 10 years ago. Okay. Well, this went to trial. So a victory for crime victims. It went to trial. Unfortunately, those 6 jurors decided that the theater was not liable in that case, but it did go to trial 10 years ago.
People weren't really reacting because you don't think shooting. I mean, I guess more recently you do because it's become more commonplace, but in 2000.
That's one of the victims in that case. I'm just going to try to get through because I know I might be running a little bit late on time here. And what I'm going to jump to with regard to the Dark Knight in Aurora is about a couple of weeks later down in Miami Beach, it's 10 days, a week and a half later, they were showing the Dark Knight, the same theater. They obviously got memos about increasing security, being very concerned because they were still going to air this movie where this happened. And our client, Maria Navis, was at that showing, and a deranged man started yelling things throughout the theater to warn everyone. The theater guardians did not go down the aisles, did not check to make sure that people were in their seats, were behaving correctly. And he yelled out, "This is it, this is it," in the front of the theater. And you can imagine a stampede started. And our client was trampled, suffered very severe orthopedic injuries. And we got to a jury on that case, and we tried that case. It resulted in a $1.7 million verdict. And obviously, we had the advantage in that case that Aurora had just happened, and they had that notice. But I think it was very important to show that in these type situations, we got by the jury, strike that, we got by the court, and then we were able to get a successful jury verdict that was upheld on appeal in this type case. And the good thing for crime victims is that the tide continues to change. This is a case where Robert Deere shot and killed 3 people, injured 9 more at a Planned Parenthood shooting in Colorado Springs. The trial court dismissed the suit on summary judgment due to lack of foreseeability and saying that the assailant was the intervening cause and that it wasn't the actions or the interactions of Planned Parenthood in this case. And then the appellate court reversed. And their reasoning was that a reasonable juror could find that the shooter was not the predominant cause of the plaintiff's injuries, and therefore the business had to be judged on what did they do wrong, what notice did they have, and what security measures did they put in place. Which again, if I go back to my theme today, in these cases, we have to put the onus, the focus on the commercial establishment, not the shooter. Whether it was targeted, whether it wasn't targeted, that's irrelevant. The defendant has a duty to provide a reasonably safe premises and follow security guidelines. Obviously, we know what happened in Vegas. In Vegas, originally, when everyone heard that, including me, I said, how could there be a case? But later on, what did we find? We found that the assailant was using service elevators illegally to get all those weapons up to his room. He had his room locked for 3 days, not allowing housekeeping in or anything along those lines. I could give you a gigantic list of how these cases change behavior of industries. If you go to any hotel right now, your room is going to be checked once every day, whether you like it or not, because of the Vegas incident. And that's some great good that came out of it. I'm not going to show you the videos there because we've all seen them. And that was a case that really changed, I think, the foreseeability with mass shootings. I want to talk to you about another case that we had. And I talk about these cases where it's not the Vegas, not the Parkland, but other mass shootings that certainly reach the national news, but after that loses a little bit of media focus. This was a case in Tallahassee, Florida, where a criminal by the name of Scott Beerley opened fire at a hot yoga in Tallahassee, killing 2 people, a young college student by the name of Maura Binkley and Dr. Nancy Van Dessem, a professor at Florida State University. In this case, I can tell you that this is a nice strip mall in Tallahassee, Florida. Maybe 14 stores, a couple of restaurants, jewelry places, very nice upscale shopping center. 1 burglary had happened previous to this terrible mass shooting. The defense in this case, the Tallahassee newspapers, even the Tallahassee Bar Association criticized us for taking this case. And what we showed in this case was that this involuntary celibate, they call them incels, who's been studied by the Department of Justice, the Secret Service, a number of different agencies, hated women. And he went to this yoga class with jeans on, with the jacket, with a brand new yoga mat with its tag still on it, asking the receptionist, is this the most crowded class you will hear today? Signed into a name under a name that did not match his credit card. And he paced for 10 minutes nervous outside the premises, where a couple of the folks coming to take the class said, is that guy all right out there? What's going on? And no one did anything. He stormed into the class and he killed my client, Maura Binkley. One of the striking instances in this case was that no one from the shopping center or no one from the hot yoga store had ever taken an active shooting or a mass shooting training at all. Although in every city, every police department across the United States, this is offered. Well, Maura Binkley was the vice president of her sorority at Florida State. Guess what class she had to take to be an officer in her sorority? The Tallahassee Police Department's active shooting and mass shooting prevention class. She had to take it to be a sorority officer, yet the businesses didn't provide it. And this case settled right before a trial date in Tallahassee, Florida. Again, after the defense said they would never resolve a case like this because it was so unforeseeable to them. I take pride in the fact that now all of these companies inside this mall provide mass shooting and active shooting training. And that's what these cases can do for us. Tobacco litigation and what we've seen there is kind of what I would like everybody to look at in terms of what we can do in these negligent security cases that are ones that we tend to turn away from. Mass shootings, domestic violence. You look at what happened through the tobacco litigation. In the beginning, no one would take those cases. They couldn't be won. And now look where we are with regard to that litigation. This is the timeline. And I think no matter what cases you're handling as a trial lawyer, but certainly in the era of working with crime victims, look how far we have come with mass shootings, with mass shooting cases. I could show you a similar timeline with domestic violence cases. There is no question that security has changed more than any other industry in the last 20 years. September 11th changed everything. We look at society now. Everywhere you go today, you will have surveillance cameras. You will be watched. You will see guardians of property, security guards. Probably everyone on this seminar has a Ring camera at their door or some type of surveillance or alarm system. Gone are the days where a grainy surveillance video can pass. Technology has brought the security industry to one of the most profitable, one of the biggest increases in revenue in the world. Forget about just the United States. Those are things that every business is charged with having. When they don't have surveillance cameras, when they don't have security guards, when they don't have logs and key procedures, they are starting behind the 8 ball. And that is something that you, as a crime victim lawyer, can use in every case. Maura Binkley was absolutely the innocent victim of a defendant's negligence in that case. Everyone told us we couldn't win it. Even the trial lawyers in Tallahassee on a listserv, I've saved the listservs for fun, told us there's no way that that type of case could be won in a rural area such as Tallahassee, Florida. So I encourage you, no matter where you are. I know sometimes some people say to me, well, you're in Miami. Crime victim cases are excellent cases in rural communities. They're excellent cases with NRA jurors. People might be looking at me as a plaintiff's lawyer saying, you're out of your mind. You kidding me? NRA, red hat jurors, how could they be good for me? And the answer is simple. Nobody feels that a place should have more security, that everyone at the store, at the school, at the shopping center who's charged with securing and keeping a place safe, everyone should have a gun. Everybody should have a gun to protect that property. Now, you may not agree with that or not, but those types of jurors can be very helpful in these cases. I'll end on this note because I know we're running a little bit late. You have to focus group these cases if you're handling them. You have to mock try them because you will learn things like I just talked to you about. We had a case in Pensacola where a little girl was kidnapped from an apartment complex, had some very tricky issues on why that tenant was allowed to live there. And I can tell you in our mock trial, the best 2 jurors was an 8-year-old little African-American girl who got kidnapped. The best 2 jurors by far were 2 middle-aged white men, one with a Make America Great Again hat on, that wanted the company to pay over $100 million and he wanted to serve on the jury to give the electric chair to the kidnapper. Those types of jurors, if you're conducting jury selection correctly and understand these issues in these cases, can be your best jurors. I'll end on that, Kim, if we have questions. I didn't get to another section, but we can maybe do that another time. But if there are questions, and I can go to Q&A.
Okay,
Kim,
I
how do
will.
you want to do it?
I'll call out the questions so we can keep things moving. Thanks. This is awesome. Rick Elsley was asking if we can obtain a link to the PowerPoint. Are you okay with us sending that to the viewers, Michael?
Yeah, I'd have to look at some of the cases, but I could take those out. So if anybody wants to contact me, and I'm just going ahead to my contact information,
Okay.
that'd be great. And Kim, I'll give you ones, maybe taking out one or two of the cases that I might have shared too much information on.
Okay. We will let you edit that accordingly. And I have posted your name and email address so they can reach out to you directly for that. H. Lee was asking how long is the webinar? Most of our webinars are about an hour. We do reserve about 10 or 15 minutes at the end for questions. Santino Finizio, good morning to you. He says, opinion about a disgruntled lover going to a new boyfriend's house and shoots him. Theory to overcome targeted nature?
Yeah, so it sounds like the new boyfriend might have been there alone. A lot of these cases, as you can tell, involve, for instance, Michael Bubnow was the new boyfriend, if you will. And those, if it's a situation where someone is going just to get the new boyfriend, I think it's a similar type situation. It all comes down to the property. When you say house, one thing, if you're dealing with a single family home, that usually is a problem, obviously. But please, even when you have single family homes or townhouses, you've got to know if there's an HOA. A lot of times an HOA will be formed and has not only common area duties, but has security duties throughout a neighborhood of single family homes. One of the biggest cases we ever had was a man who came home from, he was a flight attendant for Continental, and he came home and his house was in the middle of a burglary. He was shot and rendered a quadriplegic. But we looked at his single family home, but a homeowner association operated it, and they had 23 straight burglaries of the same group, and they knew who the kids were, and they didn't alert the police and didn't involve the police in on it, and it was a very large settlement. So these are so fact specific, but if you've got crime happening and you have an HOA, you might be able to bring that case.
All right. H. Lee is asking, does negligent security count also include, in addition to domestic violence and deaths, but also fires and floods that caused financial harm, but not bodily harm, but they were foreseeable, preventable, and predictable?
Yeah, I mean, we've had a number of fire cases, so I would put that under the premise liability umbrella, if you will. But obviously, there are a tremendous amount of codes when you handle fire cases, and so it's obviously whether it's negligent security or not hinges on whether it's arson or not. Another awful case we had once was a trailer park in Immokalee, Florida, that was for migrant workers. And you had someone going around that was just absolutely racist, awful person that had attempted to set one of those trailers on fire. Thank God it failed, came back 3 weeks later and set a trailer on fire that had chicken wire inside those windows, and the family was not able to get out. One of the most awful cases I've ever seen. So that was a code violation, obviously with the chicken wire, but also negligent security because they were on notice that hate crimes would occur and in fact had been attempted against migrant workers. So you got to know the codes there. There's some great fire experts if you need one, but it may delve into an arson and therefore a negligent security case.
Okay, very good. I like this question from Michael D'Angelo. He says, does the general knowledge that the U.S. suffers an average of an active shooter incident a week suffice as foreseeability for a mass shooting case, or does the venue still need a pattern of violent persons' crimes to further support that opinion?
Well, I'm glad Michael didn't take offense when I was talking about certain experts. Michael is an expert in this field and one of the best that's out there. And as you know, Mike, it's a great question. in the Binkley case, we filed our response to motion for summary judgment, putting in everything about mass shootings. We treat it as it's a national problem, it's a local problem, and they're on notice about it. For instance, you can imagine in the Parkland case, obviously the Broward County School District was on notice, not just they obviously knew about Sandy Hook or Virginia Tech, but it was in their training materials. So my attitude is obviously it is a national problem, but it's going to depend on the judge. The law is all over the place on that. We're in a case right now with Walmart, a negligent security case. Two of my partners are picking a jury today, and that's always an issue. How much of Walmart's national notice may come into a local store? Their notice may come in, but maybe that homicide in Shreveport or that homicide in Chicago may not. That's going to be a very judge-driven, court-driven outcome.
That'll be interesting to watch. We have a question from Lamar Alejo, and he's asking, any insight as to what happened with any of the Orlando Pulse cases and why none of those were successful?
Yeah, that really was an issue in terms of the premises owners of insurance. There was not nearly enough insurance to compensate all the victims in Pulse. I know that there were some peripheral type cases brought against different defendants, but in terms of premises liability against the owners, that was an insurance issue.
Okay, and here's one from Kelly Joyner. And Kelly, thank you for asking this question. When do we start adding the states in our lawsuits because of lax gun laws? Georgia's recent constitutional carry law is one of those.
Well, it's a great question. You know, we're limited in most states by sovereign immunity, and the government may have immunity. It depends on your state. But, you know, as you mentioned, constitutional carry, when I was giving my last talk at the American Society of Industrial Security, shopping mall owner in Texas asked me, well, what do I do when we have stand your ground and everybody can have open carry? How do I secure a place with that? And it's a great question. And that's a huge problem for businesses. Imagine I can just walk around like the Wild Wild West. I was watching, 1883, the Yellowstone prequel last night. And that's what I guess what we want to return to in the United States. And all I got to say is somebody looked at me wrong or threatened me and I can shoot and kill them. Well, how is a business going to defend against that? And that's where I go to the business owners. And when I talk to them at ASIS, that they need to oppose these laws because they are going to have the Wild Wild West in a shopping center when you combine stand your ground and open carry. So it's a huge problem. Suing the state is going to depend on your particular state, whether you can bring a case against them with your immunity laws.
Very good. David Kleinberg asked, will you have these materials available for download? Again, Michael's going to review those, pull out anything that he thinks shouldn't be shared, but we'll be sharing the majority of that. So I have his email address on the screen, so you can reach out to him directly for that. Marshall Lawson is asking, are you aware of a set of industry security standards for event venue rental facilities?
Yeah, again, if you're handling these cases, ASIS, which changes its name every couple of years, now they're going to Global Security Exchange. Their convention, fall convention, is in Atlanta this fall, September or October, I believe. And Marshall, there is a set of standards on every industry. There's a book, for instance, and it's so awful that we have one, but there's several books on house of worship protocols for churches, for temples, for mosques. When I first read that 10 years ago, I couldn't believe that we had this. Well, you look at what's happening, we need it. And there are standards for event venue places. I don't have them offhand, but definitely contact me or become a member of ASIS. And those are very interesting cases. We have a number of those. The problem with those cases, we actually have an article on that I'll be glad to send you, because it's one thing for a nightclub that operates every night. It's a whole nother thing for these pop-up clubs and shopping centers where the shopping center isn't set to deal with it security-wise, and the club just opens up for one night and they don't have long-standing trained security guards. And those things are a nightmare. And that's where a lot of these shootings happen.
Absolutely. My friend Mike Daisley in North Carolina. Hey, Mike, he's asking, can you speak to restaurant customers who were injured during an armed robbery attempt, such as when a customer is shot by a robber who is trying to force a cashier to hand over cash from the restaurant's register? What experts are helpful or necessary, and what information is most helpful and essential in such cases?
Well, I think the first thing is what's great about those type of cases, and we've had them against hotels where the clerk is being robbed, and obviously convenience store cases, is it isn't targeted to your client. It's targeted to the business. So if you've got prior robberies, you are in great shape there, and everything along those lines. So I would think an expert like Michael D'Angelo, who's on here, would be absolutely perfect for that type of case. And what you want to look there too is does the cashier fight it all? Do they not follow protocols? Do they not have a emergency panic button? How much cash do they have on hand? Do they have the sign that says they only carry this much cash? There's again, back to how every industry has their own standards. We've handled bank cases, in old time bank robbery cases. I had a client who was shot and rendered a quadriplegic at an old bank robbery, but it was done by obviously somebody jumped over the counter and robbed the cashier right then and there. My client tried to intervene, which was a little bit of an issue, and was shot right then and there. So those, I really like those cases because they're not focused on the victim.
Gotcha. Rick Elsley said, thanks, Mike, much appreciated. Just really need the case law and stats so he can reach out to you directly on those. And Santino Panizio says, clarity, single family home rented by an LLC or a private owner.
Yeah, so then you get into expectations. We're dealing with this now with Airbnbs and everything along those lines, VRBOs. What is really needed for a single family home? You're not going to need a security guard if you've got no HOA or anything like that. But cameras, locks on doors, security systems, what was promised, and those kind of things can certainly be issues there. Airbnb cases are very interesting. I do a lot of drowning cases and premise liability cases. Very interesting there, but it's a new, every day it changes on every aspect. So depending on the facts of your case, that could be interesting.
Okay. Rick Elsley is also asking, have you handled any cases involving a hospital employee sexually assaulting a patient in the staff access only elevator? No camera in the elevator is my theory of crime of opportunity. Employees had no prior issues at all.
Yeah, no, we have, and not necessarily the staff access only elevator. I just had a hotel case where surveillance cameras and whether they need to be in elevators or on individual floors was very interesting, and we battled that out a little bit. One thing, when the employee had no prior issues, we always try to go to training, because there's a deterrent effect when you train employees that you're not to be alone with a patient, or you need to have someone else. You need to log in when you take this patient here, and trying to almost intimidate and deter employees from doing those types of things. But I think in a hospital, of all places, I think surveillance cameras in more locations than not is very, very important. But those, when it's a direct employee intentional act and you don't have prior issues, I think training and possibly getting an expert to talk about the coverage of surveillance cameras might be the way to go.
Yeah, but based on some cases people have asked us to search recently, I'm thinking there's a need for cameras in elevators for sure. Too much is happening in elevators. Alfonso Craig, hello, how are you? He is asking, what's the name of the source you identified that we all should be familiar with when you were referencing Brinklers procedural failures?
Yeah, so Brinkers is the company that at the time of that case owned Chili's, Ruby Tuesdays, Fridays, and those Bennigan's, if Bennigan's is still around, everything like that. So That's the company that owned them. So those are their internal procedures. But if you go to ASIS, or if you go to the National Restaurant and Lodging Association, they have similar type procedures. Really, every restaurant, every bar I've ever had a case against has some set of procedures talking about when there's a verbal altercation, that voices are raised, profanity is used, threats are used, that the procedure is to warn that person, calm the situation down, and or call the police. But that was particular to Brinkers that owned those companies at that time.
Very good. Santino is saying great insight about the HOA aspect. Thanks, Mike. Adam Langino. Hello, Adam. Does a hospital in a neighborhood where there's been many criminal acts have a duty to protect those parking in the ER lot? Is that what you're saying? Also, my case involves a lady attacked by a recently released mental patient. There were cameras, but no one was monitoring them.
Yeah, absolutely. Hospitals have one of the highest duties out there. And you can tell. I mean, when you go to a hospital, you've got to be checked in. You've got to give your ID. There's security throughout. Unfortunately, like a lot of businesses, where do hospitals focus? Where does Walmart focus? Where does everywhere focus? Inside. Now, a Walmart or someone like that might focus inside because of their product they want to protect. Hospitals obviously are protecting patients. We can imagine all the problems that happen at hospitals. I mean, babies being taken. They treat trauma patients, gunshot victims, where the offender may come to try to get somebody, a witness to a crime. So there's all these different issues, but that doesn't mean that their parking lot is left bare. And I think hospital cases are great. The one problem you run into that you need to know about hospitals, a lot of time there are public streets through hospitals. And so sometimes courts can find that they don't have a duty to actually have security on the public street. So that can be an issue. But the fact you also have a recently released mental patient, no cameras, I always talk about cameras, you're going to have experts, and not to pick on you guys again, my friend Michael D'Angelo, but the security experts going to tell you sometimes that security cameras don't deter crime. And whether that's right or wrong, we can all debate. But here's the bottom line. Juries expect security cameras. And when they don't have them or they don't work, juries get infuriated. I mean, I can look right now on my phone and I can look at every security camera I have in my house. And this is free. Security cameras aren't, but to put it on my phone is free. To not have every inch of a hospital covered, especially parking lots, all the restaurants that are out there. You think about your area community hospital. I think hospital cases are very, very good in terms of security.
Very good. Marshall Lawson is asking, what is ASIS an acronym for?
The American Society of Industrial Security. And again, they're changing their name to Global Security Exchange.
Adam Langino is asking again, are there standards for hospital security in parking lots? Ken Rothrock, North Carolina State Bar numbers in here.
Yeah, again, through ASIS, there's a particular section, much like we have different sections at our bar, that deals primarily with hospitals. And you are going to be able to get a hospital expert very easy. I've got a name of an expert that ran a number of the biggest hospitals in Louisiana. He does expert work now. And there are excellent standards for hospital security. Now, a lot of them deal with the internal stuff we talked about as well.
We do see a lot of cases reported to the database that occurred in parking lots. It's one of the search criteria that we've included for a location type. Vipul Patel, good to hear from you. He says, I'm a hotel owner. What's the best way to train considering industry height turnover?
I always tell business owners, that if you have a plan and you talk with a security consultant ahead of time and you know the crime on your property, meaning you have a relationship with the police, and every 6 months you get the incidents that occurred at your hotel, Mr. Patel, or in the area, and you then have a security consultant advising you on what to do, that's a tough case for me to win. because you tried, because you have a plan you believe in. It doesn't mean a lawsuit won't come. We all know that. That's why you should always be insured, but it means you care. Turnover is a huge problem. I mean, it's a problem with us, all the lawyers on here now with the great resignation, but I would have a real training program for everybody who starts with you. And as you know, as a hotel owner, you don't want an incident to occur on your premises. Number one, because you care about your guest. Number two, because it's not good for business. And so the more you can try, the more you can really have a good plan, I think you're going to be okay. And that's what we need businesses to do. And thank you for being on this, because it means you care, and it means what we're doing is the right thing to try to make sure these things do not occur.
It's a good thing to have a hotel owner ask this question. I commend you for that. Adam Langino, I think you've already covered some of this. It says many assaults occur in parking lots. Are there any specific standards for parking lot safety and security that you would recommend as a starting point for our research?
There's incredible amount of research done on parking lots. Parking lots are the number one scene for crimes. We all know why, because once you're in the mall, everybody's in there. But when you take it out and you're on your phone and you got your 3 bags and you're looking at your text and you're planning dinner with your partner, that's when the criminal comes. And Walmart has done studies on it. 7-Eleven has done studies on it. It's an amazing amount of studies. I would go to the DOJ. I think Google might be the easiest way to start. We've got a number of them. Your experts should have them, but parking lots, there's a lot of data out there. And one thing I would encourage everybody to do is, be creative. How many of us have been in parking lots where we see that police tower, or we see a little bit of a tower where they have surveillance cameras that hit the whole lot that looks like the police are there? Those types of measures deter crime. And when you have a parking lot that's huge, it doesn't have something like that and isn't under surveillance, I would argue that's a violation of the standards as we sit here today.
We have a question from Benjamin Schottker. Have you ever had an issue with an insurance company claiming an exclusion in their policy that states they don't cover criminal acts of third parties? And if so, how do you deal with that?
Yeah, unfortunately, all the time. Nowadays we see firearm exclusions, we see assault and battery exclusions, and there was just a great opinion, I believe, out of the federal courts in Florida that invalidated some firearm exclusion language. But they are a problem. And I would go back to Mr. Patel, make sure that you have reviewed your insurance policy and that you don't have what they call an assault and battery exclusion or a sublimit to some small number like $50,000. But these are problems. And some of them you can get around, some of them you can't. And we've sued insurance brokers and agents because they've sold to restaurants assault and battery exclusions and liquor liability exclusions. So a restaurant's got no coverage. And they're really hoodwinking the business owner, which is very unfortunate, which obviously affects our client in the end.
Absolutely. He's also asking, have you ever proceeded on a dram shop theory against the liquor license insurance? Theory being you ever served the shooter.
We have terrible dram shop law in Florida. You can only bring a case if it's a minor that was served or somebody who you can prove was habitually addicted to alcohol. We have had blended cases where someone is absolutely terribly intoxicated, and we weave that in with a negligent security theory that the bouncers, the security guards didn't do their job. So we've had that, and we all know what happens when people are overserved. So we definitely have tried to get that into a negligent security theory, primarily because our dram shop law is so awful in the state of Florida.
Thank you. I'm looking in the chat. It looks like they put some content questions in here. Some of them appear to be the same question. So let me just see if there's anything new here. Michael D'Angelo wrote in, IAHSS is the association that promulgates healthcare security guidelines. It's IAHSS.org. So that answers an earlier question. And then we have, who's the expert for the hospital security that you are referring to, Mike? I'd love that expert's contact.
I don't have it offhand, but I do have it because we presented together at ASIS. So please contact me and I'll get that to you.
Yeah, so I've got your email on here. So Rick, please do reach out to him directly. David McNeil is asking, in convenience stores that lock their own doors at night to protect their property and their employee from crime in high crime areas, do you see a liability theory for negligent security when a business invitee was shot outside the premises when there is no security present? What if the security was only inside? So I guess that leads into what we were talking about at parking lots earlier, but is there anything else you want to add to that?
Yeah, absolutely. I had a gasoline station case that we tried several years ago where same thing, everything was locked inside and our client was killed out by the pumps. And my closing argument was the Twinkies and the bubble gum got more security than the customers because they locked them outside. As you said, they're still a business invitee. They're pumping gas and they're all alone, absolutely alone.
Yeah.
Gasoline station cases have become better and better. There are great standards with regard to them. The International Association of Convenience Store Operators, I think, is the acronym. There's an acronym for everything in these industries, and it's great stuff. They're becoming better and better cases, and I love that contrast between the security inside. They've got bulletproof glass, and you just leave the customer out there all alone.
Very good. Adam just chimed in and said, I apologize about my question being unclear. We have the parking lot case at a major hospital ER. They did have security camera, but no one was monitoring them. Lady leaving the ER on the way to her car is attacked 2 times and no one came to her rescue. So it's one thing to have these systems in place. Quite another is, are they being monitored, right?
Yeah, and that's the battle nowadays. You know, do you have to? Again, I argue it's so easy to monitor them with your cell phone, with an active security guard. I mean, any decent sized hospital should, especially if you've got a crime pattern, you've got crime activity, should have security guards, some type of guardianship out there in a multi-level parking garage. I mean, that's unbelievable. We all know we go to a hospital to visit someone, you got to park on the roof. I mean, they're usually packed. So yeah, I mean, I think you can make the argument for the monitoring, but I think the guardianship security guard out there doing patrols is also incredibly important for a deterrence factor as well.
Okay, and I think we're through all the questions, and thank you. These are great answers. There's one thing I wanted to add from my perspective on this is when you reach out to us at Case Metrics on these cases, premises cases, negligent security, whatever, all the kinds of things we've been talking about today. For plaintiffs' attorneys, don't pitch your case to me like you're talking to a juror. I want to know the good, the bad, and the ugly about it so we can give you the most objective information possibly. So think about this. Anything that an insurance company or defense attorney is telling you in conjunction with what you think is a lowball offer, relay those things to me so we can deal with those issues to give you a more objective evaluation on your case. Defense attorneys, I think it doesn't really serve you well on balance to just choose a bunch of defense verdicts or cases that have been tossed out in summary judgment and send those to plaintiff's counsel. I want you to tell me the things about the case that you're concerned about as well, in addition to any strong liability defenses that you have. In order for us to give you data that's going to help you, again, it needs to be objective. And in addition to giving you defense verdicts and cases that have been tossed out in summary judgment, we want you to be aware of these big verdicts that we're seeing, and they're not just happening in large metro areas. We are seeing these big numbers in these outlying, small, traditionally conservative venues. So we want to help you be well informed so that you can send these to the insurance companies to make sure they're adequately setting reserves and giving you adequate authority to get these cases settled, as some of them, in your opinion, should not be tried. So the more objective you can be with me, the more I can help you get where you want to be. Anything else? Oh, there's one quick question. We'll try to get this in. A lot just came in. I know that we have run over. I think these are things saying thanks for the webinar. A lot of compliments to Mike. We appreciate that very much, and we agree. And it says, Kim loved the top. Would a webinar on tricks and tips that defense pulls in trial be good? Okay, we want more defense attorneys to weigh in on these. So if we have defense attorneys that are with us today and you have a niche in this industry that you would like to share with us in an upcoming webinar, we would love to have that on balance as well. Sometimes we will do both a plaintiff and defense attorney, point counterpoint, and we can do those as well. So we welcome your ideas. So do reach out to me. My contact information is in the chat as well. Michael, anything else you want to add before we let you go?
No, just thank you so much. I love the questions. Great stuff. And if anybody wants to sign up for ASIS GSX and meet me in Atlanta, let's do it. It's a phenomenal conference. If you like James Bond gadgets, you'll see the most incredible stuff that the security industry does, but your defendants in your cases do not do. So, but thank you, Kim, for having me. I've really enjoyed it.
Oh, always a pleasure. Thank you so much for your time. We'll send an email to the attendees if you guys want to look up a particular case inside the case metrics database while we monitor and navigate it for you in a scheduled online Zoom meeting. Those take about 10 minutes. You'll get an email on that. Just click the link. We will set it up at your convenience and give you a free look around. Thanks so much. Hope all of you have a great day.
Thank you.
Bye-bye.